Good day, everyone. Welcome to the lecture series of the PNP Legal Service. This is Police Captain Christy Joy B. Balubal, Legal Officer under the PNP Legal Service Special Cases Division, grateful to serve you as your Panyerong Police. For today's lecture, we will discuss the revised rules on evidence. Evidence law in the Philippines is primarily governed by the rules of court, particularly Rules 128 to 134, collectively referred to as the 2019 Revised Rules on Evidence. First, we need to know what is evidence. Evidence is defined under Section 1, Rule 128 of the Rules of Court as a means sanctioned by the rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. It governs what information is admissible in a judicial proceeding and ensures that evidence is competent, material, and relevant to the case, preventing misleading or prejudicial information from influencing the outcomes. There are four component elements of evidence based on its definition. The first component element is that evidence as a means of ascertainment or a method of discovering the truth. Evidence is a means of ascertainment. It is not an end in itself, but evidence is a means to an end. And what is that end? The end or objective of evidence is to discover the truth. It includes not only the procedure or manner of ascertainment, but also the evidentiary fact from which the truth respecting a matter of fact may be ascertained. And when we say evidentiary facts, these are facts established by evidence before a court of law. The second component element of evidence is that it is sanctioned by the rules. It means that it is not excluded by the rules of court. In judicial proceedings, the court will observe several rules and principles before an evidence can be admitted. If an evidence or an act of obtaining an evidence violated the Constitution and or other laws, then the evidence is deemed not admitted in court. For example, is the fruit of the poisonous tree doctrine. The fruit of the poisonous tree doctrine is a legal principle that excludes evidence in a trial if it was obtained illegally. The doctrine essentially says that if the initial evidence is tainted by illegality, then any evidence derived from it is likewise inadmissible. Take for example a scenario when law enforcement officers illegally search a home without a lawful search warrant or without probable cause in case of warrantless search, and thereafter found contrabands such as unlicensed firearms and dangerous drugs. Since the search is illegal, therefore, the evidence derived from the illegal search is deemed inadmissible following the fruit of the poisonous tree doctrine. In other words, evidence when obtained in violation of the provisions of the constitutions and all other laws, it becomes inadmissible in evidence. They will not be admitted in court because the second component element of evidence is that it must be sanctioned by the rules. Now, where do we apply the rules on evidence? The third component element of evidence is that it must be in a judicial proceeding. A judicial proceeding contemplates an action or proceeding filed in a court of law. So the rules on evidence applies only in a court of law. For example, is the preliminary investigation before the Office of the City Prosecutor. The Office of the City Prosecutor is under the Department of Justice, and the Department of Justice is not a court of law. Hence, technically speaking, the rigid rules or technical rules of evidence will not apply during preliminary investigation simply because the third component element of evidence is that it is applicable only in a judicial proceeding. The fourth and last component element of evidence is that it pertains to the truth respecting a matter of fact. It refers to an issue of fact and is both substantive and procedural. Substantive because it determines the facts needed to be established, and procedural because it governs the manner of proving said facts. Why do we need to present evidence in court? Under the Constitution, a person is presumed innocent unless proven guilty. Furthermore, there is a presumption that the court is not aware of the veracity of the facts involved in a case. It is therefore incumbent upon the parties to present facts in issue through the presentation of admissible evidence. What is the scope of the rules on evidence? Section 2 of Rule 128 of the Rules of Court states that the rules on evidence shall be the same in all courts and in all trials and hearings. It is guided by the principle of uniformity, which means that all courts must follow uniformly. This is a critical scope provision. However, the same section also provides that the rules may be supplemented, superseded, or exempted by special laws or regulations such as the Labor Code and its implementing rules and regulations, special rules for family courts, and so forth. It can also supplemented, superseded, or exempted by the rules promulgated by the Supreme Court such as the rules on summary proceedings, the rules on small claims cases, rules on environmental cases, and so forth. Similarly, the rules can be supplemented, superseded, and exempted by local or administrative rules. In administrative and quasi-judicial bodies, the rules of court on evidence may apply in a suppletory manner, or those bodies may adopt more relaxed or different evidentiary guidelines by virtue of their enabling laws or internal rules. Hence, the scope provision clarifies that the revised rules on evidence apply to all judicial proceedings in Philippine courts but remain subject to specific exemptions enacted by laws or by specialized rules. Furthermore, Section 4, Rule 1 of the Rules of Court expressly provided that the rule shall not apply to election cases, land registration, cadastral, naturalization, and insolvency cases, and other cases except by analogy or suppletory character and whenever practicable and convenient. Is evidence always required? The answer is no. Evidence is only required when there is a need to solve a question of fact. Evidence is not required when the issue is purely a question of law, when agreed or stipulated by the parties and in judicial notice. Now we will proceed with the types of evidence. Evidence according to form. Object or real evidence is directly addressed to the senses of the court and consists of tangible things exhibited or demonstrated in open court, referred to as evidence by autoptic preference, example of which is a knife used in a murder case. Another type of evidence is testimonial evidence. It is an evidence submitted to the court through testimony or deposition of a witness. A great example is an eyewitness. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent or other modes of written expression offered as proof of their contents. Photograph includes pictures, drawings, stored images, X-ray films, motion pictures, or videos. An original of a document is a document itself or any counterpart intended to have the same effect by a person executing or issuing it. An original of a photograph includes a negative or any print therefrom. If data is stored in a computer or similar device, any printout or other output readable by sight or other means shown to reflect the data accurately is an original. A duplicate is admissible to the same extent as an original unless a genuine question is raised as to the authenticity of the original, or, in circumstances, it is unjust or inequitable to admit the duplicate in lieu of the original. We also have direct and circumstantial evidence. Direct evidence is a proof which tends to show the existence of a fact in dispute without the aid of any inference or presumption and without the intervention of a proof of any other fact. It is a direct proof of a fact. such as testimony by a witness in a murder case who saw the actual killing, or security camera video showing a robbery and the suspect holding up the victim. On the other hand, in circumstantial evidence, the existence of principal facts is only inferred from circumstances. There is more than one circumstances which the inference is derived as proven. The combination of all circumstances is such as to produce a conviction beyond reasonable doubt. For example, is an eyewitness in a murder case who saw the defendant running from the crime scene and a security camera video showing the suspect in the vicinity of the crime scene. Threatening emails by the defendant to stab or kill the victim, and the defendant's browser history revealing a search for how to commit murder. From those pieces of circumstantial evidence, the truth respecting of a matter of fact can be established. We also have cumulative evidence and corroborative evidence. Cumulative evidence are pieces of evidence of the same kind and to the same state of facts. For example, is in a crime of theft. The two neighbors of the victims, namely Nora and Juanito, saw the defendant holding the victim's laptop while fleeing his house. On the other hand, corroborative evidence are pieces of evidence of different characters to the same point. We also have prima facie evidence. Prima facie evidence that which, standing alone, unexplained or uncontradicted, is sufficient to maintain the proposition and warrant the conclusion to support that which it is introduced. Prima facie evidence is an evidence good and sufficient on its face. Another type of evidence is conclusive evidence. Conclusive evidence is a class of evidence which the law does not allow to be contradicted, example of which is the DNA. That concludes our lecture for today. Once again, thank you very much for your attention. This is Police Captain Christy Joy B. Balubal, your Panyarang Police at your service.